Hello everyone, this is The Big Fight and I'm Maria Shakil. The Supreme Court has ruled that no sentence will be imposed on a man convicted under the Protection of Children from Sexual Offences Act, which is POCSO. Citing the unique circumstances of this case, the decision was made through the court's powers under Article 142 of the Constitution. The man, who was 24 at the time of the offence, had been convicted of engaging in a sexual relationship with a minor girl. He later married her after she reached adulthood. The couple now live together with their child. A committee of experts, including a clinical psychologist and a social scientist, was constituted to examine the victim's present circumstances and her emotional well-being. Their findings played a key role, in fact a big role, I should say, in the court's final decision. I'm quoting a part of that order which said, "The society judged her, the legal system failed her, and her own family abandoned her." That's what the Supreme Court remarked. In its ruling, the court stated that the victim, now an adult, did not view the incident as a crime. To quote the apex court again, though the incident is seen as crime in law, the victim did not accept it as one. It was not the legal crime that caused trauma to her, but rather the circumstances that followed. What she had to face as a consequence was the police, the legal system, and a constant battle to save the accused from punishment, unquote. It also called the facts of this case as an eye-opener for everyone. The court, in fact, held that the extraordinary circumstances, including the emotional attachment of the victim to the accused and their current family life, warranted the execution of powers under Article 142 to do complete justice. So on the big fight tonight, I ask, what will be the implications of this extraordinary ruling? Should it raise some concerns? Should it be seen as a one-off judgment, or will it really become a precedent in other POCSO cases? We have a panel of legal experts and activists to decode the Supreme Court ruling and its implications. But first up, let me bring in Justice Usha Mehra, former judge of Delhi High Court, who is joining us live. Justice Mehra, how do you look at this Supreme Court judgment?
You see, the circumstances of this case were such which compelled the Supreme Court to exercise its extraordinary jurisdiction under Article 142 of the Constitution. Now, this judgment cannot apply in each and every case of POCSO, because it is the circumstances where the accused was in love with the minor girl and she was also in love with him. Once she got the adulthood, she married and now they have a child. To send such a person to jail means disrupting the family, depriving the child of father's love and wife's husband. In similar circumstances, way back in 70s or maybe early 80s, there was a case of Mathura. She married, she was raped, and thereafter, media took it up. Ladies took it up that accused should be punished. Why he has been acquitted? You know, because of our cry as lady lawyers and because of media taking it up, the family, she had already married. Mathura had already married. Now when it came to her in-laws' house that she was raped, they turned her out. So therefore, each circumstance of each case are different. This cannot be a general applicable judgment.
Okay, so Justice Mehra, you are saying essentially that this cannot set a precedent. But what does it do to the larger, how will the future POCSO cases be seen then? Because, ma'am, there are certain realities of India. You know, in this particular case, it's a case of an adolescent love as well. An age of consent question is also being brought in now. So are we not realizing we should respect a minor's right to love as much as we should respect an adult's life to love?
Then you have to amend the law.
Yes.
Age should be reduced from 18 to 16, which everybody is saying now.
Yes.
And Supreme Court has also said that you must implement Section 6 of the POCSO Act, as well as take into consideration Article 21 while considering the case in a POCSO case. So once the guidelines laid down by the Supreme Court are implemented, I think many of the hurdles which are coming in the way of execution of the POCSO cases will come to an end.
And what do you see will be the larger implications in terms of support for victims?
The Supreme Court has categorically said that the state of Bengal should consider her after she qualifies the 10th board examination to give her some job. And if possible, media should come forward to help her also. It's a state duty to ensure that such a woman who has suffered in the society at the hand of police, at the hands of her own parents, at the hands of judiciary, should be compensated.
Okay, so you are saying that there should be some compensation and also support for the victims. Point well taken. But by what was clear certainly was that the Supreme Court earlier had criticized the Calcutta High Court's remarks as victim shaming and stereotyping. And that
the Supreme Court has deplored very critically. They said this is unheard of, that judge passing such a remark that it is the girls who was responsible and provoking it because of adolescent sexual activities. This is unheard of. A judge had no business to pass such a remarks. And that is why this case was taken up suo motu by the Supreme Court.
My last question to you, ma'am, particularly with regards to the jurisdiction of lower courts in similar cases. How do you think that will be impacted?
This will be a guideline for the lower judiciary.
Yes.
In circumstances where the adolescent fell in love with a person, and not very old one, but at least he was just a 23 years old boy. And girl, I don't know what is the age, but it appears she must be around 16, 17 or whatever it is.
15 is what we were told.
15, 16. So therefore, in such a circumstances, even the trial court will try to take advantage of such a judgment if the accused marries her and they are living happily thereafter.
All right. Justice Mayer, a pleasure speaking to you. Thank you for joining us here on NDTV. Let's bring in other panelists now. Mihira Sood is the advocate of the Supreme Court. Karna Nandi, senior advocate of the Supreme Court. Kasturi is actor and social activist. We also have Dr. Ranjana Kumari joining us. Karna Nandi, beginning with you, how do you look at the Supreme Court judgment? It is being seen as landmark, but very, very extraordinary at the same time.
This is a very interesting judgment from a legal standpoint, because in one sense it sweeps away the law and looks at the facts, the surrounding facts and circumstances that may or may not have anything to do with the proving the legal case. Right now, this is extremely unusual. It's a whole different philosophy of legal examination. There are many things that are troubling about this case. The fact, for example, that the man I think he was 25 and she was 14. So even jurisdictions that say that if there is consent, it won't be statutory rape, usually have something called a Romeo and Juliet clause. And what that clause is that they say that if there's, say, 3 years between the parties, then they won't prosecute. But here it's a question of 9 years. But I think what the judge has done, and let's keep in mind that today was his last day, And he still came. He lost his mother, actually, Justice Oak, and he's renowned for being a very, very compassionate judge, somebody who looks at justice. And he cremated his mother yesterday, and he came today and he delivered the judgment. And I happened to be in court at that time. And what he's done here is he has spoken to the girl, and he's understood the real position she's in, and he's invoked the Supreme Court's extraordinary jurisdiction under Article 142, and in essence, he has swept aside the law. Now, of course, he's said that this will not be precedent, but in my experience, that's not how it works. Once you make a judgment, even if you say it's not precedent, it becomes precedent, So while justice can't be done in a vacuum, and I think that taking this girl and the daughter's real situation into account and making sure that, or doing everything he could to make sure that they're going to be okay, that's really the sort of justice that we're looking for. Is it troubling? Very much so.
Okay. So, Ms. Nandi here says that it's troubling, but at the same time, perhaps a very interesting judgment. But will it really set a precedent is the larger question, because there are concerns around it. Ms. Sood, coming to you now, because this is an eye-opener for everyone. The fact here is that there are lacuna in the legal system which has been exposed. A system which has gone after a child, a minor, who went on and fought for her, seen as her tormentor. And then and her tormentor was convicted. So there are layers at which this entire, judgment is playing out. Do you see this as a case in which it is also about informal choices, which are perhaps do not fit in what is acceptable social behavior?
Yes, there are so many layers. There are so many layers to this case, and I think it also really points to the diversity in our country, the diversity of relationships, types of marriages, and differences in how people in different situations also view marriage and romantic and sexual relationships. It's very difficult for one size fits all, though of course that is what legislation tries to do, and there's a logic behind that as well. I think what the judgment has tried to do here is look more at the spirit of the law rather than the letter, and look at the intent, which is to protect innocent children, and do what is best for them. I don't know if I would necessarily say this. I don't know that I find this troubling, because I think in a way it looks at the spirit of the law and looks at the best interest of the child, who was then a child, more than the hard black letter of the law. I also do hope that this is not taken as a precedent, and Article 142 jurisdiction is an extraordinary power of the Supreme Court. It's not a power that is given, to the trial courts. So, yes, I certainly hope that this is not taken as a precedent, and these are things that should be looked at on a case-by-case basis only by courts that have the discretion to do that, which is not all the courts of the country. But having said that, yes, I think there is, it's not very clear from the media reports what exactly was her age at the time, and what was his age at the time. But I think leaving aside those technicalities, it's important to see this as yet another argument for lowering the age of consent,
yes,
and recognizing the reality of adolescent sexual relationships and exploration, and the fact that it is not always assault or abuse.
Yes.
And there is an element of consent that comes in with adolescence. And leaving aside the technicalities of this case, I think the larger issue, the one that we can take going forward, is what does this say about where we stand on that? And does it change our point of view on that?
Yes, I think the larger point certainly larger debate which should spark or perhaps a significant discussion should begin is on lowering the age of consent, because that's also a reality. Adolescent love is a reality, Dr. Ranjana Kumari. It cannot continue to be at 18 as is, and all efforts to lower it in the past has been dismissed. But this case, even if it doesn't really set a precedent legally, it should begin that much needed discussion on lowering the age of consent. Would you agree?
Well, certainly, I think POCSO needs a relook, and also this calls for a kind of, reform in terms of POCSO's own position on this issue. But let me paint another scenario to you. A 14-year-old getting engaged with whatever age, let's not say, but girl's age, we know that she was minor and she was in love with him, or she was lured by him, I don't know. But once she has had a sexual relationship, Indian society pushes women and girls, especially teenage girls and girls, that once you've had sexual relationship, you have no other choice but to go along with that person. And here, of course, the court has used extraordinary powers to, invoking this extraordinary power to deliver this judgment, where he is also taking the perception of the girl. Now, imagine a 14-year-old involved with this person, then gets married, then has a child from. So does she have any choice in given Indian society? Does she have any kind of, options to walk out of this relationship or to accept the relationship in toto? And then to tell the people that, look, I'm in love with him, this is his child, and I'm his wife. So I think this perception of this girl, when court is quoting it, then it's really failure of not only how the legal system has blamed her, but also society. We are not looking at the way
parents.
Society is treating these girls. And also Indian society, which is pushing a lot of girls in child marriage. 14, 12, 16, even today, even in spite of having a very stringent law, we know of child marriages happening. So what happens there? Is there, how then we justify all these relationships, we justify all this, very, very minor girls marrying whatever age men. And then we say, okay, fine, and the girls cannot and have absolutely no option to walk out of it. This whole sexual relationship is being seen in our society in such a manner. When we talk about this love and this kind of a teenage, desire to get into sexual relationship is seen, if when we look at the societies which give total freedom, then there is a total choice. You may have 3, 4, 5, 6 dating, and finally you decide to marry or not marry anybody. That choice is there. But do you think India has that choice? Do you think Indian society provides the teenage girls to choose and to say, but to accept? And so how much it is really voluntarily accepted, how much she's victim of the societal circumstances, or how much. So I think there's a lot to be discussed about this case, and I hope and I pray that this does not become precedence, though we all know, and Karuna is sitting on your program, I think we all know that such judgments are used, and it's a Supreme Court judgment. So certainly some way or the other lawyers are going to use it, and certainly is going to be making a bigger and long-term impact.
There was a 3-member committee which was formed, of course, to assist the victim in this particular case in what was seen as an informed decision of her own future, because she was abandoned by her family.
It wasn't. I have the judgment in front of me. And
go ahead,
Madhavi Diwan was, I have the judgment in front of me. Madhavi Diwan and Liz Matthew were appointed amicus curiae. And Madhavi Diwan said very clearly that she did not and could not have made an informed choice. And I think this is a very important point to be made.
Sure.
Because first, think of all the rules you know. even if the 13-year-old,
Maria,
had the...
Maria, I totally agree with this. I totally agree with this. I mean, we are expecting a 14-year-old to
if
make
I
an
may
informed
just,
choice.
if I may just finish, Ranjana ji,
Yes, please go ahead.
Madhavi has said here is that at the time that it was needed most, that she did not have the kind of support that she could have had from her family or from the state. So she was abandoned everywhere. Now, when we think of the age of consent, it's not actually the age of the consent, it's the age of non criminalization of the male party in sexual activity. That's really what it is, right? So think of a 13-year-old, let's all do that, everyone watching. Can that 13-year-old, when they are approached by somebody who's, I was trying to look for the age, about 23 to 25, and the sisters also get into the act, and she is encouraged, she's approached and she's kind of to fall in love with this, whatever that means, to fall in love with this much, much older man. And then essentially the mother tries whatever she can to get her back. Imagine being that mother. And the child then goes, and then after some time, the mother sort of gives up, holds up, throws up her hands, and abandons essentially the child. The state completely fails its obligation, and we all know that in such a situation, there is no question of, the state might act in a criminal jurisdiction, but in a protective jurisdiction, you'll have the Stray Child Welfare Committee that will be good and will intervene in such a situation. But even when they intervene, would the child be taken into a home? That would just be terrible, right? If you go to these homes, for the most part, across the country where they exist, they are terrible. So let's not, yes, we can have a discussion about the POCSO Act and the problems with the POCSO Act. For example, what's being shown here, mandatory reporting of sexual offences. It's a crazy provision. And the reason it's a crazy provision is because in a school, for example, the child cannot go and tell his teacher that he has been sexually assaulted. Why? Because then the teacher will have to go on pain of imprisonment to the police.
Right.
I was asked to represent, and I couldn't because I had too many other cases that day, but I was asked to represent a mother who had made a complaint to the school authorities saying that her child had been sexually assaulted, boy, and had committed suicide. And then the mother herself was prosecuted because why didn't she go to the police? This is what the POCSO Act mandatory reporting is doing to the people who love our children.
I want to understand from both the lawyers on the panel that is it now about protecting the rights of an adolescent here, or is it about a commitment to uphold the law?
Let Mihira speak, because since I've been speaking, and I'll come back.
I think, look, I think we're all agreed that the POCSO Act itself is very problematic. So, leave aside this specific law. But in general, if you are asking, is it about protecting the rights of adolescents, both male and female, or about upholding the law? I think that the law has to be interpreted in such a way as to uphold the rights of the parties. And there's a lot of scope for interpretation. I think that the POCSO Act does not give enough leeway for that, and that's a big problem with the Act. But there should be some room for interpretation where the rights and preferences, where insofar as they can be ascertained, should be taken into account. And the best interest, most importantly, the best interest as determined by, the taking into account the preferences of the minors as well as the people who are responsible for them.
Okay. Kasturi, thank you for your patience. So your thoughts before I bring in others. Please go ahead.
I do have another debate in 3 minutes, so I will try to be as concise as possible. Thank you, Karuna Nandi, for bringing up some very salient points, as well as Ms. Ranjana. For me, it was like there was a movie in the 90s called Benam Badshah. Which was about two adults. It was a story of two adults where an adult woman who's a victim of rape chooses to go and find succor with her rapist. And at that time, we thought, okay, this is a movie that was accepted by the masses, but it's a horrible idea. I mean, this is the kind of regressiveness that society has been placing on women for decades, for centuries. It's a culturally mandated thing, and we're trying to fight against it. The Prohibition of Child Marriage Act, let's be very clear. In 1929, when the Child Marriage Restraint Act came up, the age of consent or the age of marriage, so to speak, was 14 for the girl and 18 for the boy. Why did we change it? Why did we revise it to 18 for the girl and 21 for the male? I feel like now we've taken a big step backward. I mean, I understand and I appreciate the compassionate judgment that the Supreme Court gave, that Justice Oka gave in his final verdict. Because what had happened in this particular case was that the girl was completely demonized by the High Court.
That's right.
The Supreme Court, in the end, kind of upheld the same consequence, not the verdict, but the consequence is the same. The guy got away. Okay, the guy, nothing, no punishment, because the girl is crying her guts out. She has a baby. She's a teenager with a baby, and she doesn't want her one source of support to disappear because everybody else has abandoned her in the few years. I think it's been 2 years since this case started, and society has completely abandoned her. So I really am with Mihira when she says, think of the mother, think of the parents. You cannot go to court and say, I mean, in a normal case, we're not talking about Section 142. I think in normal society, in civilized society, I don't think 14-year-olds
Kasturi, we are thinking about whose mother? We are thinking about this victim who's a mother herself, or are we thinking about the victim's mother?
You know, both. That is true. I mean, here we have a teenager who has brought another child into the world. I mean, it's not her fault alone, but it's society. But I feel like law should not submit to social regression. Law should be a tool to get us out of the malaise that we face in society. Instead, we are stuck in a rut where we don't know whether we need to do this compassionately or whether we need to follow the line of the law. I mean, it's really unfortunate. I think the parents of a teenager who has been in a consensual relationship with a much older guy, I'm the mother of a teenager. You put me in that situation, I'm going to be like, what the hell? My daughter doesn't know jack shit. She is not in a position to make life decisions at 14. It's not happening. If you want, keep it at abeyance. Give a provision in POCSO where you keep it at abeyance till the victim comes to adult age and then make a decision. But do not go ahead and just marry. What did the court do today? Marry the girl. I mean, she was already married, and not even a symbolic punishment. Nothing. This is going to completely encourage a whole generation of sexual offenders. I'm very afraid about that.
Ranjana Kumari,
Yes.
the point being made here is also the other view. And Ms. Kumari, my question is, because the top court has gone ahead and said that the broad directives for nationwide compliance with child protection laws, mandating that the judgment be circulated to all states and union territories for review and policy action. What will this actually imply?
Well, that's what is shocking also, that till date we have not circulated it. Till date, nobody has such information. Why? Why? When we have POCSO, we have all kinds of cases which are coming up. So I think there is a deeper
I'm
debate
sorry to
between age.
interrupt. I thank everybody on the panel, but I have to leave. Thank you so much.
Sure, Kasturi, thank you so much. Let's bring in others on the panel. Continue with the discussion. Please go
Okay.
ahead, ma'am.
Okay, Maria. So the question is between agency and consent. The court has looked at her consent and also, of course, the court's perception that law has really unintentionally harmed the one who law was supposed to protect. But what agency did she have? What agency does she have to take that decision? And that's the whole thing at the moment in India, that when we look at women's rights, when we look at girls and teenagers right, we have to accept the fact that we are not giving them any agency. Then how do we believe in, or how do we justify their consent? One mother just now said that I will not keep it in abeyance till a girl is 18. I mean, 18 or 21 is not what is important. Important is that the girls who are at this age, and if they have gotten into this kind of a relationship where you saw the whole story. I mean, I just read the whole story very carefully. I mean, here's the sister involved, here is, so all those circumstances in some way or the other looks like that pushed her into it. Then she had no option and choice, and she just, this could be my interpretation and interpretation someone like me, but
But ma'am,
what
who
I just want to
assisted
question,
her?
what agency does she have to make that decision?
But ma'am, who assisted her in making her understand her rights and options?
Nobody assisted her.
She's
I
a
mean,
13, 14-year-old.
look at the way the whole thing unfolded. She gets involved with him, then of course she gets married to him, then of course sexually is used. I won't say what court is saying now. Sexually, he was not using her; he was in love with her. And then imagine such cases coming from all over the country. Imagine it's happening everywhere. How do we protect our teenagers? How do we the girls are given the right to protect and all to walk out of such a relationship? What choice does she have? Family has disowned her. Where will she go? She might as well live in this relationship, and she might as well accept, because child is also involved. Don't forget that. And a single girl of that age trying to bring up a child. So what perception are we talking about? Perception is the compulsion here. The kind of circumstances she is a compulsion. So I would say that there is a whole idea of consent and agency. If there is no agency, you can't really say that this is her consent.
Okay.
That's what my whole argument is about.
Let's try and wrap it up. And I'm going to begin with you, Ms. Nandi. Of course, we are trying to understand that how this entire crime in one view is being viewed. What was seen as a crime is now being seen as a right of a victim who decides to save the person who inflicted her that crime. So it's a very complicated case.
Yeah.
Do you think what Ms. Kasturi said, particularly even if it was about symbolic punishment, the accused should have been given any punishment and that was needed? Ms. Nandi.
What Ms. Kasturi said a couple of very interesting things. The first thing she said was that there should have been a symbolic punishment, and I tend to agree with that. And the second thing she said was that, and that's a very interesting idea that could be perhaps read into the law, or the parliament could consider it. I mean, the details would obviously, we would all have to think about it a bit more. But that while, and this is an interesting point that Mihira Sood also raised, a different point. Mihira said that the evolving capacities of the child should be recognized. Now, consent is not a binary. While a 13-year-old, in my view, has absolutely no capacity to provide informed consent, and Madhavi Diwan's opinion on that here is quite clear as well and contributed to the judgment. There is the evolving capacity of the child. The child has feelings. The child also has sexual feelings. Does the child have the ability to, in an informed manner, act on those sexual feelings, particularly when faced with a 25-year-old or, thereabouts? Absolutely not. Where does that leave us? we have to think about the system that deals with children, not just as penal alone. If there is going to be a paternalistic law that says that they have no agency whatsoever in these matters till the age of 18, then the state absolutely must. There is no option but to provide welfare options,
Okay.
to provide proper homes, a great system where they can go. Is this possible? Not today. It's not.
Okay.
Like, you really should visit one of these welfare homes. These are terrible places, And this is why women in domestic violence situations do not leave if they can't go back to their parents and if they don't work, because going to these shelter homes is not an option.
Right.
The child.
Okay.
Therefore, I think Justice Oak's wake-up call for the welfare system to really fix itself. And I think that is the main message that we should take away from this.
Okay. 30 seconds to you, Meera Sood. Of course, we are wrapping up this discussion,
I just want to talk very briefly about, when we say that somebody doesn't have agency, I think all of us, we all live in a patriarchal society. It's not as if I or you or Karuna or, Ranjana, any of us are not, living in this kind of society. All of our choices, all of the agency that we also think we are exercising is to some extent mediated by the limitations that we see on our choices and the sort of calculations that we make on a daily basis. So it's not that any of us is operating in a system, or forget in India, anywhere in the world, it's not that any woman is really operating in a system of complete 100% agency. So, we have to accept that. We have to accept that, this level limited agency is also a form of agency, I think. And I think in the facts of this particular case, and I don't want to get too stuck on this case because, as I said, it should not be taken as precedent. Okay. We should really be talking about the larger issues around it. But I think in the facts of this particular case, she married the man at 18. So it was an ongoing relationship for 4 years. And I suspect that is also something that would have weighed with the judge. That the decision to get married to him or
she chose to be in that relationship.
Was something that was taken when she was an adult.
Yes.
And, whether or not we like it, that has to be given some respect.
Yes. Okay. All right. Of course, this is a discussion which will continue in its multiple forms and facets now. Thank you so much for joining us, Ms. Karunanandi, Meera Sood, Kasturi, and Dr. Ranjana Kumari. That's all from me on this edition of The Big Fight. I'll be seeing you next week. Thanks so much for watching.